Wasatch Report, shooting straight on everything from prepping to politics.
Well, hello, everybody, and welcome to the Wasatch Report. I'm Suzanne Sherman. I'll be your host for the next hour here on the Cerberus Radio Network, where we defend liberty and freedom from the flames of tyranny. Jeff Johnson is in the studio with me. Right now, he is taking care of his production roles, getting all the levels and everything squared away, and then he will be putting on his co-host hat. He has some great commentary to share, as always. It is March 28th, year of our Lord 2019, getting closer. We are in spring, but Utah's just starting to figure that out. Looks like we're going to get some rain and snow today. I can see an old friend today. That old friend is terra firma on my driveway. That 4-inch layer of snow and ice is finally gone. So that's happy. That's happy news. Anyway, I don't have time for Weather Channel discussions today because we've got about 4 hours worth of topics to cover in the short 60 minutes that we have together. Essentially, I'm going to be discussing more of the federalism and firearms topic, particularly within the role of federal supremacy. We came across an article that I have seen people excoriating across social media, and quite honestly, it's justifiably so. So we're going to be discussing also the ban on ARs in Deerfield and what a state court has in Michigan decided to do with that one. Bump stocks, 60,000 of them destroyed in Texas. I'm crying. Also, we'll catch up with Donald Trump's executive order on EMPs. We meant to do that yesterday. We did not get a chance to do so. Please follow us, beg your pardon, on Facebook, Cerberus Radio Network. CRN is our fan page. Suzanne Sherman's The Wasatch Report is also there on Facebook. Should be up and running. I think I have 3 more days of hard time to serve in the Facebook correctional facility. I'm well rested this morning, Jeff. Apparently the cat stayed outside all last night, so the Friskies Grand Prix did not take place indoors. So I'm up and at 'em and ready to go today. First, a quick update. Sometimes I go on Fox News and do a quick check. And apparently the headline is Donald Trump now is vowing to have the DOJ and FBI, because we know how honorable and trustworthy they are, they're going to probe the prosecutor's handling of the Jussie Smollett race hoax case. By the way, staunch libertarian, but not federalist, Judge Napolitano says Trump is right. The case is a national embarrassment and needs to be reviewed. Well, yay. Here's another example where, yes, this was a distasteful result at the state level. Jeff, where in article, let's see, there are three crimes that the federal government has the authority to punish. I'm not seeing hate crime hoaxes in there. All I see are counterfeiting, treason, and piracy on the high seas. But you know what? When you're king, you can go after anybody you want for any reason. I think what he did was absolutely reprehensible, Jussie Smollett. And by the way, I think it was a great publicity stunt because I'd never heard of him. I'd never heard of the show. But now everybody's talking about both of them. So good on you. You can also follow us on YouTube. We are live. We broadcast live, and we have a live chat. So if you are watching on YouTube, join the fun. SoundCloud, if you can't listen live, go to our SoundCloud page. Everything is available there for free download. I have all of this accessible on one page until we get our Cerberus Radio Network up and running. You can get this on my page, SuzanneCSherman.com. All of my articles that I reference during the show, I've got a few I'll refer to today within the context of our topics. You can find them on that page under Suzanne's articles. You can go to blogs also. I have some more preparedness articles on there, and I kind of put some of the, particularly with the last one that the 10th Amendment Center published, that was from my blog. So you can find our stuff there. Everything from CRN. You can also find there's a social media banner, and you can hit the SoundCloud button, the YouTube button, and access all our shows. We're really trying to consolidate so you don't have to chase our stuff everywhere. So again, I'm not going to take any further time and discuss the Smollett case. I do have an announcement. One of my Facebook friends and somebody that I follow regularly, and we're in some groups together, has decided to run against Che Guevara, aka Alexandria Ocasio-Cortez. And there's an article, it's actually a hit piece. I can't call it a legitimate article, from the New York Daily News.com. And Bronx Republican plans to run against Bolshevik, and they put in quotes, Representative Alexandria or whatever, AOC, in the next election. And this gal's name is Ruth Papazian. She will be in contact with me today. We're going to try and get her on the show next week. She was actually had her first interview with Martha McCollum on Fox News last night. So we'll be following up and getting in touch with her. And I think that's exciting. Does she have a chance of winning? I think she does. If she can convince the people in that community that the policies of the Marxist Democrat Party are actually hurting them. Jeff, didn't we just say yesterday that the unintended consequences, and I submit to you, I don't think they're unintended consequences, actually hurt the people they're claimed to help. Look at minimum wage laws, rent control laws, the war on poverty, so this will be interesting. We'll get her in there as well. So we'll look forward to hearing from her next week. We will also, as I said, get into the executive order regarding EMPs. That'll tie some preparedness into there. I want to start out with some very sad news out here from Utah. As you know, I like to share a little bit of the Utah flair, and this is actually tragic. And this is something that subjects, it's a risk to everybody. It doesn't matter where you live. And it shows we are justified when we tell you every regulation, every law is ultimately enforceable by death. If you resist, you can be killed. So can somebody else. And this is what happened just the other day. A driver was chased by a Utah County deputy because he had kidnapped a child. No, I'm just kidding. He did not kidnap a child. He was chased by a deputy over a registration violation, ran a red light, and he killed an 80-year-old man. Now the sheriff's office may change its pursuit policy. May change. So let me get into this article. This is from the Salt Lake Tribune. Utah County SOs bringing an outside agency to review its pursuit policy and is paying out an undisclosed amount of money to a family of an 88-year-old man who was killed when the subject of a deputy's pursuit ran a red light and struck his vehicle. Let's just pause and discuss the first paragraph alone. The sheriff's office is not bringing in an outside agency. They are bringing in somebody that we are paying for. The way it's said here, it makes it seem like they're responsible for their own misdeeds. No, and they are not paying out an undisclosed amount of money. We, the taxpayers, are. Can you imagine living almost 90 years to have it all end because the Crown wants the registration for the horseless carriage? Jeff, before we went on the air, you and I were having a conversation about this. What could they have done differently?
Well, they could have just not had the chase to begin with, over a few dollars. Besides the fact it was over registration. So he obviously ran the registration to find out that it was expired or whatever it was. So that means he knew where the person lived. He knew who the driver was. So the crime can be taken care of. The crime of not paying for your registration and, for the stop, it could have been handled at the house because eventually the guy was going to go home. So someone died over a little bit of money that the Crown wanted to extort from a person at gunpoint.
And I wasn't making fun of the example, for instance, when somebody kidnaps a child. That's a life or death situation. I can understand some sort of a hot pursuit or more of an enhanced pursuit to save the life of a child when we have somebody in imminent danger. This imminent danger was money law enforcement knew was owed to their superiors So now they're going to get it no matter what. Do you really think this man's life was worth ending over this? And, these hot pursuits, this is nothing new. They're saying now we got to we need to review our policies. This has been going on for decades. There is absolutely no excuse for this whatsoever.
This is not just law enforcement. The fire service, the EMS service, they've all had to reassess how they proceed to emergencies. They've slowed down because so many fire trucks are going through lights, killing people. Ambulances are going through lights, killing people. You're not doing anyone any good if you get in an accident. That engine doesn't make it to the fire, or the ambulance doesn't make it to the emergency. So they've all had to reassess what they're doing. And I think the fire service and the EMS service have done a better job of diffusing the problem and stopping the tragedies. Not completely, but for the most part.
Yeah. So, again, you can read the article in its entirety. It's in the Salt Lake Tribune, and they're going to weigh whether the risks of the pursuit are not warranted by the nature of the offense, or whether the weather and traffic condition, who cares? You guys should have done this decades ago and made these changes. So shame on them. And I know people who blindly support the police activity. I call balls and strikes. Will say, well, the person should have pulled over. The person that was in the chase should have not tried to elude the police officers. We know people are going to do this. And as you mentioned, Jeff, there are other means by which they could have pursued their desire to enforce the law and collect this revenue. But a man had to die for it.
We talk about this with Greg all the time, with all the new technologies. Yes. With all the cars now today with OnStar and everything else, they could have just walked away from it, just pulled over to the side of the road, got on the line with OnStar, gave them all the information, and they could have shut the car off.
Exactly.
I mean, they didn't even have to chase the guy. They could have pulled to the side of the road, let him go, and handled it, and they would have got him anyway. So here's the deal. This is just over money. This had nothing to do with a serious crime. No one's life was in danger until that officer put everyone's life in danger by chasing the guy.
Yep, absolutely. I think this is absolutely reprehensible. And there's just this, it seems to be this feeling that law enforcement has the right to just do this and protect their own. Also, this goes back to, I was thinking of the case where the individual was killed in a police pursuit that resulted in Nurse Hubble and that officer being ultimately fired because he tried to get unlawfully a blood draw from the victim of a police pursuit to see if this truck driver was under the influence of, say, marijuana or any other drugs. Why? Because he wanted to exonerate the police officer involved in the chase. So I hope this results in some serious changes out here.
And that truck driver ultimately died.
That person ultimately died as a result of a police pursuit.
And he wasn't the object of the pursuit. He was, again, an innocent bystander that was caught up in this pursuit because of what? Getting money.
Yep. So again, we don't even call them, when I was growing up, we called them police officers, and they were your friends. They were the ones that you were supposed to go to, for instance, if you were lost. Now you go to a cop if you're lost, and CPS will probably come knocking down on your door. So, and they're law enforcement officers. I shared the story before of a friend of my parents in Los Altos who told my dad, be careful when you're driving, because all my dad would really do is go to the gym and back in his car. He said, you make sure when you go to a stop sign, the wheels stop turning. My mom was actually pulled over once because the wheels did not stop turning completely in a stop sign. Not that she ran it. She didn't just downshift. But the wheels, she stopped, but not completely. Make sure you don't go a mile an hour over the speed limit. Make sure you use your turn signal. Why? Because we have been instructed to pull everybody over for every violation. Why? Not to keep the street safe, but because there was a budget shortfall. So that's the reality of it, folks. I want to change now to the result of a gun confiscation plan that has been permanently blocked. We've talked about this before, Jeff. There was a Deerfield, Illinois, had a ban on what they refer to as assault weapons, and a judge in Illinois. Now, this is why I support this, because this is preemption, state preemption. We did not have a federal judge come in and invalidate a state law. That's what we call incorporation, and we know where I stand on that. So this is an article that talks about a judge in Illinois has torpedoed a town's plan for gun regulation that included both the confiscation and destruction of ordinary rifles. The victory was announced Friday by the Second Amendment Foundation, which opposed the ban by, again, the village of Deerfield over these weapons. We are delighted with the judge's decision, which we hope sends a message to other municipal governments that they cannot try to sneak around the state's preemption statute in an effort to ban legal firearms ownership. And this was a quote by Second Amendment Foundation member or founder Alan Gottlieb. Last year, we were granted a temporary injunction by a circuit court, and the order making it permanent solidifies our position. So now what happened here in 2013, Illinois had adopted, or Deerfield had adopted this ban, claiming it was an amendment to an ordinance that was adopted a few years ago designed to regulate firearms after the state passed its preemption statute in 2013. And that statute essentially said that only the state had the right and the power to regulate firearms. So what the 19th Judicial Circuit Judge Louis Baronis signed the permanent injunction saying the gun ban ordinance contained language that would have allowed confiscation and destruction of so-called assault weapons and their original capacity magazines, and levy fines of up to $1,000 a day against anyone who refused to surrender their guns. Jeff, we've talked about this before. The reason people will eventually hand over their firearms is they won't be able to deal with these draconian either sentences, like they will be felons, or these draconian fines. $1,000 a day? This is a kind of legislative extremism has no place in American soil, he said. The Deerfield Village Board tried to pull a fast one, and the court stopped them. It's just one example of how the Second Amendment Foundation is winning firearms freedom one lawsuit at a time. Well, we'll see about that. The complaint last year pointed out a 2013 amended state statute that declares the regulation of the possession or ownership of assault weapons are the exclusive powers and functions of the state. Okay, so that's good. Here's the problem, and this is where we're going to get into now why we are ultimately going to lose the right to our firearms under the system as it exists today. Because this article so far, so good. Deerfield defines the weapons it intended to destroy as semi-automatic rifle, pistol, or shotgun that has the capacity to accept more than 10 rounds of ammunition, plus another feature, we call those evil features, as defined in the ordinance. That includes the common AR-15. So here's how the article concludes. The United States Supreme Court ruled in 2008, that would be Heller, that citizens have a constitutional right to keep a handgun in the home for self-protection. And the court extended those rights to the states in 2010. That would be the McDonald case, the city of Chicago. That incorporated, again, unlawfully, according to the Constitution as ratified, the Second Amendment against the states. Remember, this was intended to be within the purview of the states alone. So here we have a state effectively nullifying under preemption a municipal ordinance. Good for them. I'm glad they did it. Now what we need to see are the states stepping up and nullifying federal laws. We're going to get to that. I want to also touch on an article that our good friend Dwayne Stovall posted. As you may know, Dwayne Stovall is running for Congress as an independent. He's too Republican for the Republican Party. in the state of Texas, hoping to unseat John Cornyn, who, by the way, has, I don't think, ever come across a gun control law that he did not like. So let's see. This is out of Fort Worth, Texas. One of the country's largest bump stock retailers has turned over its entire inventory to the government Tuesday to be destroyed. RW Arms, which is based in Fort Worth, said it transferred. Now remember, this law provides for no grandfathering in and no compensation for these now, once legal, now contraband items. Transferred 60,000 bump stocks to the Bureau of Alcohol, Tobacco, Firearms, and Explosive, which, by the way, have absolutely zero constitutional authority to exist in the first place. So who's the criminal here? The people that decide to keep their bump stocks, or the people that decided to ban them and then enforce that ban? I submit to you, it's the latter. They were taken to a local facility to be shredded and recycled. I wish we could do that with our politicians. Repurpose. As of March 26, we talked about recycling yesterday, didn't we, Jeff? As of March 26, all bump stocks are officially banned. Yeah, well, so what? Any remaining bump stocks must be destroyed and are illegal. Our remaining inventory is being crushed, and we're not all down about it. We still have several top name brand products available. So if you want to know what the taste of boots would be like, ask these guys, ask this company, bootlickers. So here, the Justice Department, on orders from President Donald Trump, banned gun accessories that were used in the massacre in Las Vegas 2 years ago. By the way, they never did come to any conclusions as to how or why this came about. There were so many red flags, no pun intended, that came about as a result of the facts that came out, but no conclusions. The one thing that occurred as a result of this is more rights have been taken away from we, the people. And we're okay with it because, you know what? Nobody needs a bump stock. You know, I'm okay with this. I'm okay with this because bump stocks aren't accurate and they're dangerous. That's not the point. And when we have these Second Amendment activists, particularly the lawyers, saying the same thing, this is why we will lose. Speaking of which, I'm going to get into more attorneys botching the Second Amendment. Let me finish this one up, though. Some Texas gun owners are disagreeing with this policy. I'm not going to comply, but I'm going to fight for everyone in the state of Texas and this country, said Michael Cargill, a gun rights activist. Cargill owns Central Texas Gun Works in Austin and is suing the ATF, the USAG, and the Department of Injustice. See what I did there? He says the decision to ban the bump stock should be up to Congress. Jiminy crickets! Jeff! No, it's not up to Congress, for crying out loud. This is the problem. We have capitulated the fact that there is zero authority for the feds to regulate this at all. And then when we say it's up to Congress, we surrender this. Well, the president can't do this, but Congress can't. No, you should be thumbing your nose, giving the finger, ignoring these clowns in D.C. every time. The states do it over a friggin' plant. 33 states in Washington, D.C. have legalized marijuana in one way or another. But everybody wants to lick the boots of the feds when it comes to guns. Knock it off. If you step on the rights of people who believe in the Second Amendment, then my job is to put my foot on your throat. Well, of course, unless it's Congress doing it. Then he'll just slit his own throat. It's a novelty. It's not even a tool. The firearm itself is a tool. When you're talking about the enforcement aspect, it's going to be virtually impossible. One thing you have an issue is you don't have a Texas law, for instance, and you're going to be able to charge with something like that. Chief Justice John Roberts declined a request for the court to get involved Tuesday. A second request is pending in front of Justice Sonia Sotomayor. Again, this shouldn't even be an issue. The states should be saying, ban whatever you want. We're not going to comply. Now, Jeff, weren't you telling me about a Missouri statute? And we've had other states try to do this as well. I think Wyoming also, that said, look, if guns aren't coming across state lines, federal law does not apply here. Hello, states. Federal law does not apply regardless. Regardless. People have just given this up completely. Now, here is an article from AmmoLand, and the headline, I'm not even going to get into the body of the article other than one sentence, and you will see why. But the headline says, believe it or not, Second Amendment supporters are winning the argument. Never before has it been more difficult to get a firearm than it has been now. This started under Republican control of both the House and the Senate, a Republican president, and the NRA. The NRA backs this bump stock ban. We know that. Now, here is what they claim is why we are victorious. And this, they are waving the victory flag for this. In essence, this is the closing statement here, the closing paragraph. In essence, between the Heller and McDonald ruling, as well as the Second Amendment Foundation / Defense Distributed Settlement, the Second Amendment supporters have won the big arguments and hold the high legal ground. The only way to blow it is with bad strategy and tactics or failing to think about how our support for the Second Amendment comes across. I don't think these people even know the 10th Amendment exists. As I said before, these people don't understand the big picture. The big picture, ladies and gentlemen, is federalism. The F word, not the N word, nationalism. Federalism. Let's review. Federal government was intended to be limited in nature with very few defined, remember the word, enumerated powers. Everything remaining not prohibited to the states remained with the states. The Constitution did not grant the states any powers. They delegated the powers to the general government, powers they could reclaim at any time. They also could withdraw and leave at any time. That was the pre-1861 America. The post-Lincolnian 1861 America, these people are right. But again, if you say this is the way it is and this is how we have to work within it, it forecloses the possibility of ever winning. Heller, Antonin Scalia ruled that the Second Amendment means you have a right to a handgun in your home for defensive purposes. That's not what the Second Amendment means. The Second Amendment simply reiterates that this was never, ever a topic to be addressed by the general government. And here we claim this is a victory. Then it gets worse, and we dig ourselves even deeper and say, now, not only are we going to ignore this restriction, but now we are going to restrict the state's original power to regulate them exclusively for their own citizens with the incorporation, again, contrary to the intent of the 14th Amendment, against the states. More power to the feds at the expense of the state and local representation. These are not victories. When people come out here and wave the victory flag, ultimately it is a noose around our necks because the feds are never going to let go and grant more gun rights. They are always going to restrict them. We're talking about mandatory insurance. We are talking about extreme risk protection orders, bump stock bans. What did Donald Trump say to Dianne Feinstein? I'm open to discussing assault rifle bans. Screw all of you. All right, now I've got this article. This
Hold
has
on,
been,
Suzanne, before
Yeah.
you move on.
all right.
Ed asking in the chat.
Oh, hi, Ed.
What's that?
Hi, Ed.
He asked, Suzanne, if I remember correctly, the Illinois Constitution, and I'm going to read it because he left out one word, and I don't know that it really makes that much difference, but because he didn't put only. Subject only to police power, the right of the individual citizen to keep and bear arms shall not be infringed. That's Article 1, Section 22 of the Illinois Constitution. So he asked, let me continue on with the question. I understand that to mean local. I could be wrong. Perhaps this is a good place to explain preemption.
Well, essentially what we're talking about, for instance, and this is like a smaller version of the supremacy clause. So what we have here, let's use the word supremacy here. The state constitution, the state regulations, which should not, by the way, and this is another topic altogether, be in violation of their own constitution. So California, again, according to the 10th Amendment, could outright ban firearms if they so desire. Why? Because California's constitution is silent on firearms. Pennsylvania, your home state, Jeff, says the right to own firearms shall not be questioned. I submit to you there are many firearms in the state of Pennsylvania. So states are ignoring their own constitution. The issue becomes one of jurisdiction. What is the appropriate forum in which you can seek redress? I say to you, first of all, you have to seek redress within your own state, elect different officials, amend your constitution. If you cannot effectuate a change in your own state, like I could not do in California, you find one that better suits your desires with regards to the whatever it is you're choosing, be it marijuana, be it firearms. That's the concept of federalism. That's why 13 sovereign and independent states / nations came together to form a compact where they could have local policy decisions decided among themselves for their people. And then the general government had its obligations that essentially set up common defense in a free trade zone and dealing with foreign nations. That was it. Now we have
I think what he's asking is about the preemption in Illinois, their constitution. So I think what he's asking is because it says subject only to police powers. So he's seeing police powers as a local thing, and that police powers are a local thing. So that was his question. How can this be a local thing, but they're preempting the local law?
And now I'm getting to how this applies to the states. It's just another version of this where the states have their own constitution, and now the police are trying to come up, or local towns are coming up with their own versions. And just like we have the argument for national reciprocity, well, people should be able to go where they are and not be criminals because they cross a state line. That's kind of the policy for preemption with regards to the state of Illinois. Well, what if you're passing through there? Could you be arrested, or if you live there? And again, I like local consent of governed, but again, we have the state laws. So I don't know if I'm answering his question or not, but the preemption law says in the state of Illinois that you cannot have municipalities having a law that contradicts or conflicts with the state law. Does that make any sense?
And that's what I put in the chat, that the local governments cannot pass a law that is in contravention to the constitution of the state or laws in the state. So as long as the state of Illinois has not banned these firearms, the local can't go and ban them, because then it's a contravention of state law.
It's just another version of federalism, just at the state levels. And the difference being, according, again, in the Jeffersonian America, not the Lincolnian, Hamiltonian America, the states were not mere subsidiaries to the whole. It's different at the state level, where the counties and municipalities are subsidiaries to the whole of the state. So that's really what they mean by preemption. I'm going to turn now to this article that I know it raised your blood pressure, Jeff, and I saw somebody else on my Facebook feed put this up, and they were absolutely up in arms, no pun intended. But this article here, it was actually written by an attorney. He's local out here in Utah, and I emailed him, and we've been corresponding. I will repeat what he told me in the emails. Again, there's nothing confidential here. It was just our discussion about this article, because I did invite him on the show, and he was not available this morning, which is fine, because I don't think Jeff could get Xanax on hand that quickly. I know you don't keep any in the house, and I know you'd need some to get through listening to him defend this stuff. But here's what he says here. This is called concealed nation. Well, they get it wrong right there, don't they, Jeff? They use the N-word. Shame on them. Understanding the supremacy clause and why federal nullification laws could land you in prison. So I reached out to him. And what he said yesterday, I said, I'd like to discuss this with you. And he said, please tell me what the context of this conversation is going to be. And I said, it's really about federalism. And he says that he's not teaching the way it should be, which is what we talk about all the time. We try to apply, again, 18th century ideas for 21st century thinkers. We try to apply current events and the principles upon which this union was founded to, again, what we're dealing with today. So he says he understands things aren't the way they should be, but what he does teach is the way they are right now. So he quotes himself from the article. I understand why gun owners love the idea of nullification laws. Most gun owners, myself included, recognize there has been significant overreach by the federal government in regulating firearms. Gun owners cannot afford, however, to operate in an abstract reality of what should be. We need to be firmly grounded on the reality of what is. Okay, remember this sentence, the reality of what is. He puts forth a definition of the supremacy clause that has absolutely nothing to do with reality. Again, I'm not trying to bash the guy because he's not here. This is very common. We have attorneys doing this all the time. Let me refer you to the article I wrote at the request of Don Livingston at the Abbeville Institute, The Problem with Lawyers and the Constitution. They are not taught constitutional history. The author of this article also, unfortunately, is a lawyer. Jeff, I don't think we're going to have time to discuss the executive order today because I don't want to rush through this, but we can do that next week. So he starts out by saying that there is a phrase, ignorance of the law is no excuse. And he asks the question here, can a state pass a law invalidating, nullifying, he does know the word nullifying, all federal laws within the state boundaries? Well, that's an unfair question because some federal laws are valid. So when you ask, can a state law or invalidate all federal laws within their boundaries, you have to answer the question in the negative. Could the state of Utah, for example, nullify all federal firearms laws within the state, allowing residents to freely build their own fully automatic or other NFA weapons? My answer, yes. The accurate answer, also yes. Could the state of Utah, he also asked, likewise pass a law nullifying all federal income taxes for labor performed within the state of Utah? Remunerated, labor performed within the state of Utah. The answer, of course, is an emphatic no. Well, once again, we had a constitutional amendment for the passage of the income tax. So
and it's dubious because a lot of people will argue it was never actually ratified in the sense that it should have been under Article 5.
We could do a whole show alone on the corruption that went into getting that passed. So I think it also passed.
There is some ambiguity there.
Well, again, he's asking questions that are disingenuous. First of all, the first question I raised, I already answered. But then the second question, he says here, this was passed by a constitutional amendment. There's been no constitutional amendment, again, with regards to firearms. So he also concludes there appears to be a large and dangerous misunderstanding about this topic in the firearms world. Look in the mirror, sir. A recent article by the Sentinel, and this is going to the one that you were talking about in Missouri, has been spreading like wildfire on social media and illustrates this misunderstanding well. The article relates to a recently proposed Missouri law, which purports to nullify all federal laws relating to firearms in the state of Missouri. I'm not going to read the law because we don't have time, but the Sentinel describes the proposed law as perhaps the most monumental step toward freedom and individual liberty since the signing of the Bill of Rights, framing something as the most monumental step since the signing of the Bill of Rights is a pretty intense way to describe anything. I'm going to skip through here a little bit.
Besides, the Missouri Senate bill, and I don't remember the number now, is up on our Facebook page on CRN, and I've posted it twice, so it's a little higher up and it's lower. I'll find it again and I'll put it at the top of the page again.
Okay, great. Now, here's where he goes into his analysis, his constitutional analysis. Some background. Missouri would not be the first state to enact one of these laws. Roughly 10 other states have enacted similars in the past decade. 30 have proposed similar laws. The fact that Missouri isn't even among the first 10 states to do this makes the Sentinel's description of the law more curious. And the basis for doing this is that firearms made, sold, or produced, remember we talked about some of these articles or laws within the borders of the states, Montana, Idaho, Utah, Wyoming, Arizona. He names a few. The basis for doing so is that firearms made, sold, or produced entirely within a state are theoretically not subject to interstate commerce and therefore not subject to any federal regulation. For many reasons, some of which are discussed below, these laws do not and have never been actually provided the protection they purport to provide. And they don't. We discuss that, for instance, with marijuana laws in the case of Raich versus Gonzalez. I'm not going to go and rehash that here, but that is, again, another example of the state standing by and allowing the feds to trample over the rights of their sovereign citizens when it comes to a regulation that the state had every right to enact, and the feds had zero, but the feds went in anyway. So here is what he says is the legal framework for nullification laws. And Jeff, there are two resolutions that he has never even mentioned in this article. The legal framework, he said, is important to keep note up front. It is important to note up front that these laws have lost each and every legal challenge that they have encountered. Not so. With regards to marijuana, 33 states, including DC, have thumbed their nose at Congress, at and also the Controlled Substances Act and the DEA. I'm not aware a single time one of these laws has been upheld in court. And I will say he is correct. The understanding is you violate these firearms laws, the state's not going to back you up. And they should. It's their obligation. Now, he hangs his hat here on the supremacy clause. Remember the phrase in the email. He's also a constitutional teacher. He teaches constitutional law, by the way. This is what's scary. The supremacy clause of the Constitution is found in Article 6, Clause 2. And that's the only part he gets right about the supremacy clause. The Constitution and the laws of the United States, which shall be made in pursuance thereof, and I'm going to just get to the relevant part, shall be the supreme law of the land. Okay, and this is his analysis of the supremacy clause. In plain speak, the supremacy clause says that when state and federal law conflict, federal law always wins. This is a constitutional law professor, lawyer, teaching what I learned in middle school in the public education industry. When you have state and federal law, according to this guy teaching future lawyers, the federal law always wins. There's more analysis here about other cases. I'm not even going to spend more time on this. This is absolutely incorrect. This is not the principles upon which we were founded. I was going to go through this whole article, but I see that we're running low on time. So what I'm going to do now is shift
minutes.
What?
We still have 15 minutes.
Oh, I know, but I'm going to spend some time right now on the voice of reason, the 10th Amendment Center, Understanding Federal Supremacy. I'm not going to pick that article apart, but the premise is there. Federal law always wins over state law. There's absolutely no mention of the Virginia and Kentucky resolutions. I want to share Mike Meharry and the 10th Amendment Center's thoughts now and give you the accurate information on the Supremacy Clause. The Supremacy Clause stands as one of the most misunderstood and abused provisions of the Constitution. I just gave you a glaring example. Again, Article 6, Section 2, the Constitution and the laws of the United States, which shall be made in pursuance thereof, shall be the law of the land. Again, it doesn't say anything about federal law always trampling state law. They have to be made in pursuance of the Constitution. Are federal firearms laws of the United States made in pursuance to the Constitution? Absolutely not. Laws outside the delegated powers are null and void. And here's what Mike said, and this is great. Most lawyers, academics, and politicians read this to mean that the federal government does whatever it wants, and the people and the states and the state governments unquestionably submit and questioningly submit. Well, our friend here that wrote the other article is absolutely correct. And by counting on your states to keep you out of trouble, if you violate these laws, is going to get you arrested. That is he's correct in so far as he goes there. The problem is his analysis with the Supremacy Clause. And yes, he is talking about things the way they are. Again, if you stay within the argument of what the Supreme Court says, what they have ruled on the extent of their own powers, meaning the federal government, we're going to lose. We will never, ever make America great again, take our nation back if we stay within the confines of this discussion and say, well, federal supremacy, we have to work within what the Supreme Court said. We don't see the Supreme Court expanding our firearms right. Again, Heller was not a victory. So here, most lawyers, academics, okay, so again, Thomas Jefferson disagreed. The several states composing the United States of America are not united on the principle of unlimited submission to their general government. Mike goes on to say, that was a quote from Thomas Jefferson, the absolute federal supremacists tend to completely ignore the key words in the Supremacy Clause in pursuance thereof. The clause does not read, the Constitution and any old act Congress decides to pass shall be the supreme law of the land. Now, that is essentially when this guy here explains what the Supremacy Clause means. That's exactly what he's saying. What he's saying is the Supremacy Clause says when the state and federal laws conflict, federal law always wins. There's no defining caveat there. There's no qualifier that mentions within the purview of the Constitution. And this guy's teaching future lawyers. I'm not trying to bash him, but for crying out loud, this is what we're seeing all the time. This is the extent of the analysis in not only the mainstream media, but a lot of these smaller gun rights activists. Remember that discussion I had with Charles Heller in Arizona on that show on our old network, Jeff? Same thing. Even libertarians want to seek favor from the general government in expanding our gun rights at the expense of state sovereignty, even though the general government is marching inexorably towards more gun control, more confiscation. Absolute federal supremacists, again, ignore in pursuance thereof. Even Alexander Hamilton, the nationalist who wanted a king for life, expressed federal supremacy in Federalist 33. Again, this other guy doesn't quote any of these founding principles. He just says the feds can do whatever they want under the Supremacy Clause, but doesn't get into any of the history behind it. If a number of political societies enters into larger political societies, the law in which the latter may enact pursuant to the powers entrusted to it by the Constitution must necessarily be supreme over those societies and individuals to whom they are composed. It will not follow from this doctrine that the acts of the large society, which are not pursuant to its constitutional powers, but which are invasions of the residuary authorities of the smaller states, will become the supreme law of the land. These will be merely acts of usurpation and will deserve to be treated as such. Hence, we perceive that the clause which declares the supremacy of the laws of the Union, like the one we have just considered, only declares a truth which flows immediately and necessarily from the institution of a federal government. It will not, I presume, have escaped observation that expressly confines the supremacy to laws made in pursuant to the Constitution. The Constitution limits federal supremacy to those objects falling within the general government's delegated powers, not one iota beyond. Now, he also mentions St. George Tucker. I mentioned him in our articles, I think also on the AR-15 and national reciprocity. Carl Jones and I wrote as well. You can get more into that analysis here, but essentially what he says, a law limited to such objects as may be authorized by the Constitution would, under the obstruction of this clause, be the supreme law of the land. But a law not limited to those objects or not made pursuant to the Constitution would not be the supreme law of the land, but an act of usurpation and constitutionally void. So by capitulating and saying, well, these laws, or because of the supremacy clause, the states are going to lose every single time. That might be the reality, but only because we are kept ignorant by articles such as this. We are kept ignorant because in the law schools, we are taught case law. We are not taught the Constitution and the Constitution history as ratified. We never mentioned the ratification debates in law school. I never heard about the preamble to the Bill of Rights in law school, and this is why we are where we are today. And this is why, thanks to the federal takeover, the national takeover, pardon my French, of the education system, mainstream media, licensed grants provided by the federal government, will always err and sway to the side of the expansion of federal government power. And when we agree that this is the way it should be, and when those teaching future lawyers say this is the way it should be, we have more future generations of lawyers, judges, legislators, putting us towards a stronger top-down centralized government that will eventually, it's only a matter of time, severely restrict, if not outright ban firearms. You might say that will never happen in America. Mark my words, we're seeing it more and more. Any comments, Jeff?
Well, all you have to do is read the articles that I've been posting up. You have Graham, you have Cruz, you have other big name Republicans that are all on board with gun confiscation, these red flag laws, and they're going to work together with the Democrats to pass them. And we already know Trump will sign them because he already said that we'll take the guns first and we'll worry about due process later. So, you know, to think that we have two parties is a joke. They're two sides of the same communist Marxist coin. They're all going to do what they do to protect their power. And articles like the one you're talking about that made my head explode the other day are just feeding into the propaganda that the federal government rules us all. We have one united state, and the states are just merely counties in the big state now.
And that's exactly what Alexander Hamilton wanted. That is exactly what Edmund Randolph and James Madison proposed with the Virginia Plan. Again, that was rejected outright. We say that time and time again. And yes, this gentleman is correct. Again, he says this is why a state law can't pass a law that nullifies a federal law they don't agree with, such as income taxes. Again, he's using apples and oranges. Income taxes are a result, dubiously, I will agree, of a constitutional amendment. So he is putting unconstitutional laws and constitutional laws in the same basket. That is an absolutely disingenuous and dishonest proposition here.
Apples and oranges.
Yes, and then he says, this is not how it works. That's not how any of this works. No, you know what? What doesn't work is the system that you are saying that we have. Again, to say that we cannot nullify anything, I don't think he's ever heard of the Virginia and Kentucky resolutions. James Madison, Thomas Jefferson, at the request of those states, respectively, drafted resolutions in response to the Alien and Sedition Acts. So, by his analysis, the Alien and Sedition Acts were completely justified and constitutional, and the states had absolutely no rights to ignore him or ignore them. By this gentleman's analysis, the states had no right whatsoever to nullify fugitive slave laws. Think about what he is really saying. What he is saying is over 320 million people are subject to the rules and regulations of unelected bureaucrats in Washington, D.C., 535, let's say 500, maybe 33 criminals in Congress. There are about two of them I like, Rand Paul and Thomas Massey. And then we've got the judicial temple monkeys. If everybody looks to see what they say, that is one unelected, appointed for life, unaccountable official for every over 30 million. How's that for governed by the consent of the governed for you? So this is the problem. We are ignoring the fact that the states not only have the right, but they have the absolute obligation to nullify federal laws that overreach the powers delegated to them. I know I spent more time on this than I intended to, but what he relies on, again, turning back to this first article, is court justifications on how they rule on nullification law. Well, this is the flaw of the Constitution in and of itself, is the federal judiciary has turned into a weapon against our federal system. They have turned it, the federal judiciary has turned to the system by which we have nationalized everything. Read Government by Judiciary by Raoul Berger. Check out the Incorporation Doctrine in the 14th Amendment by Dave Benner. Who Killed the Constitution by Kevin Gutzman and Tom Woods. The Politically Incorrect Guide to the Constitution by Kevin Gutzman. Don't look to see, just because the federal judiciary keeps overturning state laws doesn't mean it's right. I understand this guy is simply saying that is what is, but when your analysis as to why that's the way it is so flawed, when you can't even get the supremacy clause right, you need to look further. Let me refer you to an article I wrote for the 10th Amendment Center. States need to step up and protect marijuana users from federal gun laws. This is another example of nullification, and the states can absolutely do this. You can find this on SuzanneCSherman.com. And again, the states have the power to protect. Now, what they did in Prop 2 out here was the state in Prop 2 said, look, we're not going to use any state resources to protect or to arrest anybody that's using medicinal marijuana that also has firearms, because that is federally prohibited according to ATF purchase transaction form 4473. What the states need to do is step up and prevent the arrest or the gun confiscation, just like they should have done in the case of Angel Rach in California. Prop 215 granted her the right to use medicinal marijuana and grow her own plants. The DEA came in, took her plants away, destroyed them, took what she had to use to keep herself living pain-free from a very, very horrific malady. And the SO just stood right by. And I've had people say, well, then what's going to happen? You're going to have standoff, aren't you? Are the feds going to open up on a sheriff who is protecting the constitutional powers of this lady? No. we're not done with this topic by a long shot. We will get to the EMP stuff next week, Trump's executive order. On behalf of the rest of us here at Cerberus Radio Network, I'm Suzanne Sherman. Thank you for listening. God bless you.